Mr. Price testified that at the SNS Grocery, which is a 51% business, that he did see the defendant chasing another male with a handgun. He was descriptive enough to say he was heavy set, he had no shirt on, he was driving a dark blue Lincoln Navigator.
Okay, quick breakdown here. Mr. Randall is on probation, but the state's accusing him of breaking multiple conditions. Now, probation is basically a second chance mess up, and that leash snaps tight, and guess what? Randall admitted to 6 violations already. It's like telling the judge, yeah, I dropped the ball 6 times. Yikes.
Driving a dark blue Lincoln Navigator that the police pulled up before he left that premises and followed him. We know from Officer Powell that he followed that same vehicle until it crashed out. Inside that vehicle, or the vehicle was obviously driven by the defendant in this case. Inside that vehicle was a silver or chrome pistol, just as he described. That was the aggravated assault, was exhibiting a deadly weapon in the course of chasing the victim in this particular case.
All right, thank you. Mr. Smith, the defense?
Your Honor, as to count 7, that has to be found untrue as to what evidence was presented. The law of Texas is that a person commits a UCW if they carry a handgun in a grocery store. It becomes a felony of unlawfully carrying a weapon in a licensed premise.
Are you talking about 7 or 8?
I'm talking about
Positive for meth and THC. That's not just striking out THs like showing up to the ballpark with a broken bat and no shoes. Remember, judges don't just look at the crime, they look at the pattern. And Randall's track record here, let's just say it screams red flags. What do you guys think? This guy's self-sabotaging or what?
7.
7's not the unlawful carrying a weapon on a premises. 7 is the aggravated assault with a deadly weapon.
Okay, well, I misunderstood the answer. I'm talking about the count of the unlawful carrying a weapon.
That's count 8.
All right, that's count 8.
And I'll cut that short. I don't believe I have enough evidence on count 8 with regard to the premises and what the percentage of is an alcohol premises and things like that. I don't know that there's enough evidence on that. So I'll find count 8 not true. Let's talk about count 7.
Yes, Your Honor, on count 7, we would argue that as we showed in the testimony from Mr.
Price.
That the statements that he made to the police and the handwritten statement that he made at the time of the offense are so inconsistent with his testimony here today that his testimony is simply not believable. In addition to that, the testimony from Mr. Price that he saw somebody chasing somebody with a handgun, the best way to describe that is that he saw somebody with what he thought appeared to him is a handgun. That does not prove, as a matter of law, that was a handgun. And so that evidence before the court that this man was chasing somebody else with a legitimate handgun, that proof is totally insufficient as a matter of law, and we would ask the court to find that to be not true.
Anything else from the state with regard to argument on that?
Judge, there was a handgun that was found in the vehicle. The fact that he chased him from business to business, both in the car and out of the car, certainly I think there's enough evidence to find him guilty of the aggravated assault.
Or find it true. So obviously, I, just like a jury, can make reasonable conclusions and deductions based on the evidence, and the level of proof necessary in a motion to revoke is obviously substantially less than that in a jury trial with a jury. I think the evidence from Mr. Price, the evidence from Officer Powell, there was no real lapse in anyone having their eyes on that vehicle and Mr. Randall at the time, from the call in to the cops getting there to him leaving and being the only person in the vehicle.
Hold-up officer sees the suspect's vehicle right in the grocery store lot. Imagine. Going in for milk and bread, and boom, there's a high-speed chase unfolding. Forget express checkout, this is felony lane, aisle 3.
With the gun being found that matched the description of the gun, somewhat that Mr. Price saw and that Ms. Officer Powell found in the actual seat of the driver. I am going to find count 7 true. So that makes, there were pleas of true again to counts 1 through 6. I'm finding counts 7 and 9 true. So now, Mr. Bruce Smith, argument with regard to punishment. The underlying offense, just for the record also, that Mr. Randall is on a deferred probation for is aggravated assault causing serious bodily injury. That was a 10-year deferred probation. You may proceed.
Your Honor, we would argue that what my client pled true to in counts 1 through 6 are all administrative counts. He pled true to those, and but they're all dated back in 2023. It's my understanding that he got all that problems straightened out, and that the probation department was fixing to put him on reporting like every other month rather than every month, which indicates to me that they thought that he had straightened out his act.
Where do you see that? Is that in the report?
No, that's not in the report. That's just my understanding.
Okay.
And the statement, as far as the
And there it is. Randall crashes his Lincoln Navigator straight into a garage. Not parked, jammed. Picture Fast and Furious, but without the skills, money, or soundtrack. Oh, and there are already 2 cars in that garage. Talk about a 3-car pileup in someone's backyard.
the pre-sentence investigation update, the statement indicates and verifies that my client has had, medical problems in the past. And they repeated that he was taking medication back at the time, that he was having these problems back in 2023, and that the medication had an impact on him that caused him to have these problems.
I want to make that's what he said to them.
That's correct.
Okay.
Yeah. But I think the record as a whole in your file indicates that he did have problems, mental health problems in his past. In fact, was seen going to a local dental top and was on medication. In that, we would submit that was the problems back in 2023, and that since that time in 2023, it wasn't until we have these problems in 2024 that we would have this motion to revoke. So we're asking the court to take into consideration the fact that for a long period of time he was having only administrative difficulties in his probation, and that, and I think that's important for the court to take into consideration. Since the court made a finding of true as to counts 7 and 9, we're asking the court to, if it doesn't see fit to continue my client on probation, we're asking the court to, if in fact it does revoke his probation, that his sentence into the Texas Department of Criminal Justice be set at no more than 5 years.
Thank you. Mr. Philip Smith?
Judge, we filed our first motion on December 8th of 2023, after he had been an absconder for several months. This offense occurred.
Your Honor, I would object. There is no evidence of him being an absconder for this court.
Now this is huge. The silver handgun, the same one dispatch reported, was found right on the driver's seat. No bag, no hiding spot, just sitting there like it paid rent. And remember, possession in law isn't just about holding something, it's about control and access. That little detail, game changer.
It's in the PSI, and you had no objections to the PSI. He failed to report February 20, he pled true to failing to report February, May, June, October, and November of 2023.
Yeah, that's correct, Your Honor. But I mean, absconder means he just disappeared.
Well, he did disappear. They didn't see him.
He admitted that there were certain days that he did not report. And those were the dates that he did not.
You did not
report.
object to the pre-sentence report, which also, we have the, you're the probation officer, correct, Ms. Bryant? Would you please come up? Good morning, ma'am. Well, good afternoon. Would you please raise your right hand? Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And I'm going to do this a little informally. We're not going to get into a whole lot of questions. You stated in the updated pre-sentence report that that after the defendant had not reported for more than 90 days, that he was changed to an absconder status December 5th of 2023. Is that correct?
Yes.
So from February until then in December, February of 2023 to December of 2023, how many times did Mr. Randall report?
Oh, and here's the defense move. The officer never actually saw Randall chasing anyone. That's their angled no first-hand witness, just dispatch notes. It's a smart tactic, but is it enough to create doubt? Stick around, because this trial's about to heat up.
And if it's helpful, you can set your stuff down on the podium or whatever up here with whatever you need.
You said from February of 2023?
To December.
Four
Okay, and when was the last reporting?
of 2023 was August 10th.
Okay. All right. So once you hit December and that 90-day mark is when you guys changed it to absconder, and that's when that motion was filed and administrative hearing was done, correct?
Yes, ma'am.
What about any information that you have with regard to Mr. Randall participating in Spindletop services?
Me personally, I don't have any information. I wasn't an officer at the time.
Okay. Is there anything in the file that you can tell that shows